Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation. Announcements by the Speaker.
Honorable members, I have received correspondence from 18 members of the opposition of their absence from today's sitting.
Bills brought from the Senate. The Electronic Payments into and Out of Court Amendment Bill 2021 in the name of the Attorney General.
Attorney General.
Madam Speaker, in accordance with Standing Order 64(1)B, I beg to move that the next stage of the Electronic Payments into and Out of Court Amendment Bill 2021 be taken later in the proceedings.
Honorable members, the question is that the next stage of the Electronic Payments into and Out of Court Amendment Bill 2021 be taken later in the proceedings. All in favor say aye. Aye. Any against? The ayes have it.
Questions on notice. Question for oral answer.
Honorable members, in light of the absence of the members in whose names questions on today's order papers stand, these 18 questions on notice for oral answer have now lapsed.
Public business. Government business. Bills second reading.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Electronic Payments into and Out of Court Act 2018 be now read a second time. Madam Speaker, as we begin the holy month of Ramadan today, I say Ramadan Mubarak to the Muslim community of Trinidad and Tobago and extend that equally to all of our brothers and sisters across every religious sphere. Madam Speaker, I say that because today we are graced with a significant amount of calm, and we are here assembled to make laws for the peace, order, and good governance of our society for the betterment of the situation in which we stand. The bill before us, Madam Speaker, proposes an amendment to the Electronic Payments into and Out of Court Act 2018. The bill has in it a proclamation clause for commencement, and then the substantive clause, clause 3, proposes an insertion of a new section to the parent law. This new section is a new section 16 and provides that where electronic payments are to be made into court, the judiciary of Trinidad and Tobago may, by agreement with a financial intermediary, cause the bank charges, credit card charges, debit card charges, chargeback, administrative and other fees to be deducted from the custodial bank accounts referred to in sections 5(1) and 2 of the Parent Act. I've taken care to refer to those particular provisions, conscious of the fact that we amended this parent law twice already. Firstly, by Section 30 of the Finance Act 2018, which is Act number 19 of 2018, and secondly, by Section 34 of the Miscellaneous Amendment number 2 Act 2020, where we brought about improvements to the law, always taking those steps to do that. Now, Madam Speaker, it's important to put this in the context of the other laws that operate together with this particular bill and the Parent Act. And I'm doing now so specifically for the purposes of Hansard. This law coordinates under and inferior to the Constitution of the Republic of Trinidad and Tobago. Secondly, this law also operates in conjunction with, that is alongside, the Exchequer and Audit Act, Chapter 6901, the Exchequer and Audit Electronic Funds Transfer Regulations 2015, the Electronic Transactions Act, the Financial Institutions Act, the Electronic Transfer of Funds Crime Act, and, Madam Speaker, therefore, the law must be read as a whole. And I'm saying this because by this particular bill, we are proposing to set a template for the digitization of this economy and also for the move towards as much a cashless society as is possible. This bill is also tacked on to and drives the process of delivering relief to a category of people that are referred to as the unbanked. The unbanked in society are a large number of our citizens who do not have the benefit of a bank account and who have to conduct business, very often involving merchants or services that require electronic payments, but which they cannot access because they do not have bank accounts. Now, the parent law speaks in conjunction with this amendment. And the parent law is very, very, very important because it provides the structure by which we must treat with these particular provisions. Permit me, therefore, to address that in the context of the amendments now before us. The parent law sets out, Madam Speaker, who the collector of revenue is in Section 3. That's under the Financial Regulations 1965. What the court is, that's every court, including the Magistrates' Court. The parent law sets out what a custodial bank account is. This is critically important because there are two types of custodial bank accounts. There are custodial revenue bank accounts and there are custodial trust bank accounts. It sets out who the financial intermediary is. And that is the intermediary approved by the Minister of Finance, acting as Treasury, pursuant to the Exchequer and Audit Electronic Funds Transfer Regulations 2015. The parent law sets out the receiver of revenue, and the parent law sets out at Section 5 that fines, fees, and any other monies in the nature of revenue made by an order of court or rules of court, they are one category altogether that must go to the custodial revenue bank account. And then they set out maintenance payments or other payments which are not by their nature revenue. For instance, where you pay monies into court by way of security for costs, etc. That money does not belong to the state. And the state, Madam Speaker, includes the judiciary. The state includes statutory authorities. The state includes bodies that fall across the whole panoply of arrangements that comprise the state. And what we do, Madam Speaker, in this parent law is we specifically say that you must put this money into a bank account held in the name of the Treasury, of the judiciary as approved by the Treasury. Why do we do that? This has been the case since time immemorial, since before our independence constitution, since before our Republican Constitution, where the judiciary has held bank accounts approved by the Minister of Finance, acting in the capacity as Treasury. Enter, Madam Speaker, the modern world. In the modern world, and in this government's push for digitization, in this government's push for the removal of fraud and for the ability to follow the money for benefit, we say that we wish to encourage citizens to avoid going to the court, to avoid the indignity of the court record being lost if you're making a maintenance payment. A husband turns up at the court or a wife turns up at the court and pays maintenance for a child ordered by the court. The paperwork is delayed or it gets lost, and then there's a warrant issued for arrest when the person has made payment. All of these things disappear in an electronic environment where there's a real-time, minute-by-minute, second-by-second tracking of where the money is and to whose account it stands. In this particular amendment, we seek to allow for electronic payments and for the reconciliation of electronic payments to be made in keeping with what the whole world does. The ability to go on a laptop, on a phone, on a computer, to stand up at a kiosk, to go to a merchant, to go to TSTT, and to pay for fines for motor vehicle and road traffic offenses, to pay for mask wearing, to pay for fines ordered by the court, to pay for maintenance money for a child. All of these things can be done from the privacy of your home, from the convenience of your telephone as a smart device. And what we do, Madam Speaker, very clearly and very properly, is to say that revenue is to never be touched. Why do I say that? Section 112 of the Constitution sets out that revenue must go to the consolidated fund, wherever revenue comes from. Revenue of the state, the judiciary comprising the third limb of the state is included. Revenue from the state must go to the consolidated fund. What we say in this bill is that charges which are not revenue, a bank charge, in this case the judiciary has negotiated with a financial intermediary a 0.8% transaction fee. That is not a 3% transaction fee, which is standard in the world for the use of a credit card or electronic payment. They have negotiated, and the current price is 0.8%. They have said that 0.8%, which must go to the corresponding bank, that is the United States bank that takes its fee for MasterCard or Visa or whatever it may be, that money can never be considered to be revenue. And therefore, because the international world does real-time transactions, we say the merchant agreement, the commercial arrangement between the judiciary and the financial intermediary, a bank in Trinidad and Tobago, which, by the way, is approved in the usual fashion by the institutions of governance, that merchant agreement can provide for the automatic direct deduction of charges, because that can never be revenue. That is akin to what we call caution money. If we take a witness and we want to take the witness to court and you get $100 in conduct money, that is for the witness to turn up at court. That does not comprise revenue of the state. So what this does, it allows us to avoid the paper restrictions of waiting for 1 month to reconcile gross payments. That is the fine. Let's say you have a fine of $1,000 and the charge by the bank is $8 to make that $1,000. If we were to leave this law unsettled, what would happen is the $1,008 would have to go into the consolidated fund. 1 month later, the $8 would have to be viewed as a bank charge, and the $8 will have to be paid out of the consolidated fund to the bank, and then the bank would pay to the financial intermediary. That is nonsense in the real world of where digital transactions are. The paper dynamic can never restrict the virtual supremacy of the Constitution. The Constitution in section 112 says that consolidated fund is to receive revenue. What we want to separate out here is what is not revenue. And what is not revenue is approved by the governance cycles of the whole of government and the Ministry of Finance arrangements, Madam Speaker. That's why I said this law works alongside the Exchequer and Audit Act. That's why I say, for instance, Section 13 of the Exchequer and Audit Act and Section 52 of the Exchequer and Audit Act continue to have relevance in respect of what is revenue. If we look to Section 13 of the Exchequer and Audit Act, it says, all revenue shall be paid at such times and in such manner as the Treasury may direct into the Exchequer account, and the revenue shall form the consolidated fund, but B, the Treasury may, if it thinks fit, from time to time, authorize receivers of revenue who are accounting officers to defray in the first instance from revenue collected by them, expenditure, etc. If we look to Section 52 of the Exchequer and Audit Act, Madam Speaker, and we get to the provisions in the regulations, the financial regulations, 52.1, receivers of revenue shall not make any payment whatever from revenue takings without the prior approval of the Treasury. If the judiciary in the merchant agreement was proposing to touch revenue, these provisions would apply. We are saying specifically in the law here now that charges which are not revenue will be taken out, paid to whom they are owed on an instantaneous basis. But Madam Speaker, I want to remind, the Exchequer and Audit Act is not the supreme law of the Republic of Trinidad and Tobago, the Constitution is. And in the Constitution, when we look to Section 116 of the Constitution, we must remember that the Constitution provides for the Auditor General. We have declared in the 2018 payments into and out of court legislation that this law is subject to Section 116 of the Constitution. The Auditor General has oversight over the judiciary, and in any event, the Exchequer and Audit Act, which provides for the functionality of the Auditor General in prescriptive law, also provides for the Auditor General to make sure that everything is literally above the board, that the finances of the Republic of Trinidad and Tobago that comprise the consolidated fund are whole and integral and balanced. But what this amendment allows is for charges which are not revenue, which are still subject to the supervision of the Auditor General, for those charges to be deducted in accordance with what Section 112 of the Constitution provides, which is by way of an Act of Parliament. Now, I've taken care to put that on the record, Madam Speaker. I would like to inform that yesterday, after the sitting in the Senate, when this bill was considered, I received correspondence from the Law Association asking certain inquiries. I asked for responses for those inquiries to be sent to the Law Association, and they were today. We have addressed some of the small issues that were raised there, largely based upon some misconceptions as to the operation of the government financial structures. I don't mean to be pejorative or demeaning in any way to the Honourable President of the Law Association who caused the letter to be sent. I welcome the letter and have answered it, but there was nothing concerning the bill itself which occupies any concern in today's processes and sitting, Madam Speaker. Obviously, this is a bill which deals with the process and not the money, and therefore we are within safe parameters to consider this law as a whole. In those circumstances, I beg to move.
Honourable members, I shall now propose for debate the question. The question is that a bill entitled An Act to Amend the Electronic Payments into and Out of Court Act 2018 be now read a second time. Attorney General.
Madam Speaker, I thank the honourable members of this House for their support in this legislation, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Electronic Payments into and Out of Court Act 2018 be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Electronic Payments into and Out of Court Act 2018.
Attorney General.
It's properly déjà vu. In this case, I've already said it and not seen it. So, Madam Speaker, I thank honourable members for their kind support, and I beg to move.
No, please. It's now committed to the committee. Sure.
I'm using the Deputy Speaker's order paper, not mine. Forgive me. Madam Speaker, in accordance with Standing Order 68.1, I beg to move that the Electronic Payments into and Out of Court Amendment Bill 2021 be committed to the Committee of the Whole.
Honourable members, the question is that the Electronic Payments into and Out of Court Amendment Bill 2021 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. This bill has 3 clauses. Attorney General, can we take them en bloc?
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stand part of the bill. Honourable members, the question is that the bill be now reported to the House. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This committee meeting is now adjourned. General.
Madam Speaker, I wish to report that the Electronic Payments into and Out of Court Amendment Bill 2021 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with this report from the committee.
Honourable members, the question is that this House agree with the committee's report on the Electronic Payments into and Out of Court Amendment Bill 2021. All in favour say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Electronic Payments into and Out of Court Act 2018 be forthwith read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Electronic Payments into and Out of Court Act 2018 be forthwith read a third time and passed. All in favour say aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Electronic Payments into and Out of Court Act 2018. Motions.
The Minister of National Security.
Thank you very much, Madam Speaker. Good to see you here, Madam Speaker. Madam Speaker, motion number 1, notification of the nomination of Ms. Bliss C. Prasad as a member of the Police Service Commission. Madam Speaker, I beg to move the following motion. Whereas Section 122, subsection 3 of the Constitution of the Republic of Trinidad and Tobago, Chapter 101, the Act, provides that the President shall, after consultation with the Prime Minister and Leader of the Opposition, nominate persons who are qualified and experienced in the disciplines of law, finance, sociology, or management to be appointed as members of the Police Service Commission. And whereas Section 122, subsection 4 of the Act, provides that the President shall issue a notification in respect of each person nominated for appointment under subsection 3, and the notification shall be subject to affirmative resolution of the House of Representatives. And whereas the President has nominated Ms. Bliss C. Prasad to be appointed as a member of the Police Service Commission, and whereas the President has on the 26th day of March 2021 made a notification in respect of the nomination, and whereas it is expedient to approve the notification, be it resolved that the notification of the nomination of Ms. Bliss C. Prasad as a member of the Police Service Commission be approved. Okay. So, Madam Speaker, we are here today as we were just a few days ago doing important business and doing the business of the people of Trinidad and Tobago, subject to and under the guidance of the Constitution of Trinidad and Tobago. On the last occasion we were here, on Friday of last week, what we did from a national security perspective was extremely important and critical to the continuation of the national security apparatus of Trinidad and Tobago when we dealt with the nomination of a Deputy Commissioner of Police. Here today, a few days later, we are dealing with a notification from Her Excellency the President with respect to her nominee, her nomination of a person who served as the former chairman of the Police Service Commission. And it saddens me that once again, in the space of less than a week, we, the elected members of this House of Representatives, who took an oath to Trinidad and Tobago, an oath to serve our country without fear, favor, malice, or ill will, find ourselves absent of 19 members, elected members of the House of Representatives of Trinidad and Tobago. And it would be remiss of me, as a citizen of Trinidad and Tobago, someone who sees it as a privilege to be elected by the people of Trinidad and Tobago, in particular from Port of Spain North, St. Anne's West, to not place on the Hansard my great disappointment at the shenanigans, the theatrics, and the continued misinformation, false premises relied upon by those who are absent on the other side, and how they try to politicize a medical condition of the Honorable Prime Minister. And I stand here today and I chastise them in their absence, and I would say to them in their face, and I also put on record my personal condemnation as a member of Parliament for the absence, once again, of the opposition, and there is absolutely no scientific or medical data to support their absence here today whatsoever. Having said all of that, Madam Speaker, we're here today to do the people's business, and in particular, in accordance with the Constitution, to deal with the nomination of Her Excellency the President of Ms. Bliss C. Prasad. Ms. Bliss C. Prasad is one of those persons in private life who rose to the call, and a call to serve Trinidad and Tobago by Her Excellency the President. Ms. Bliss C. Prasad served, I believe it was a 3-year term, as the chairman of the Police Service Commission. And during her tenure chairing the Police Service Commission, we've gone through 2 processes, again in accordance with the Constitution. One, for the selection of a Commissioner of Police, and I remind the population once again, the current Commissioner of Police was not supported by the absent opposition. And then on the last occasion we were here, we also dealt with the successful conclusion of a recruitment process in accordance with the Constitution of a Deputy Commissioner of Police, Mr. Jacob. What we're here today as a government to do is to endorse fully the nomination of Her Excellency, the President, and to say that we, the government of Trinidad and Tobago, who take our duties very seriously, in addition, national security falls under us. So we're here today to make sure that national security can function properly by having a proper quorum of a Police Service Commission. And we fully endorse and support the nomination of Ms. Bliss C. Prasad. If my colleagues would just bear with me as I take a few minutes just to put on the Hansard the exemplar that Ms. Bliss C. Prasad is. She has, as her areas of expertise, financial and investment management, loan negotiation, debt restructuring, strategic planning and development, compliance management. She's a facilitator and a trainer in compliance, financial and risk assessment for lending, preparation of business continuity plan and disaster preparedness plans, tax services for individuals, partnerships, small businesses, preparation of feasibility studies for new business ventures, conference planning and management, process re-engineering, client development, and networking. To have a citizen of Trinidad and Tobago with this level of expertise in that area come forward, offer herself up, and once again be nominated by Her Excellency to serve as a member of the Police Service Commission, that should be taken note by all other citizens out there. Rise to the occasion of service. I'm pleased to say one of her key accomplishments, Madam Speaker, is she was the first woman elected to the management committee of the Queen's Park Cricket Club. She's the first woman elected as the president of the Trinidad Building and Loan Association. She's reduced delinquency in the mortgage portfolio from 95 to 20% to ensure the viability of Workers' Bank. She successfully increased market share of the mortgage market at Scotiabank between 1995 and 1998. Madam Speaker, briefly, her education in 1977 to 1980, she achieved a Bachelor of Arts Honours in Geography and History. 1981 to 1982, a Master of Arts in Urban Geography and Planning from Michigan State University. 1984 to 1987, she completed Level 2 papers of the Chartered Association of Certified Accountants. 92 to 94, postgraduate diploma in Business Administration. 1997, an IBOTT postgraduate certificate course in Global Trends and Financial Markets. Madam Speaker, if I had to go through Ms. Sipasad's CV, we would be here for a bit more time than I'd like to detain my colleagues. What I can say is that the government, without hesitation, under the guidance of the member for Diego Martin West, the Honourable Prime Minister, have absolutely no hesitation in accepting the nomination of Her Excellency the President, and we fully endorse, without any reservation, that Ms. Bliss Sipasad be returned as a member of the Police Service Commission. Madam Speaker, I beg to move.
Honourable members, I will now propose the question for debate. Be it resolved that the notification of the nomination of Ms. Bliss Sipasad as a member of the Police Service Commission be approved. Minister of National Security.
I beg to move, Madam Speaker.
Honourable members, the question is, be it resolved that the notification of the nomination of Ms. Bliss Sipasad as a member of the Police Service Commission be approved. All in favour say aye. Aye. Any against? The ayes have it. Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, we have concluded all the government's business on the order paper. As a consequence of that, we will adjourn to a date to be fixed. Thank you very kindly, Madam Speaker.
Honourable members, the question is that this House now do adjourn to a date to be fixed. All in favour say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned to a date to be fixed.